When Texans think about gun rights, confiscation usually isn't the first thing that comes to mind. But it does happen during arrests, protective order cases, mental health interventions, and even routine traffic stops. In this video, we're breaking down exactly how firearms get seized in Texas, the legal process for getting them back, the mistakes that stop people from reclaiming their guns, and 2 real Texas court cases that show how the law works in real life. Stick with me, every Texan gun owner needs to know this. Here are the most common, legally recognized ways a firearm can be confiscated in Texas. During an arrest, if you're arrested and have a firearm on you or in your vehicle, officers may seize it under Texas Code of Criminal Procedure Article 18.19. Family violence or protective orders. A court-issued protective order can require firearms to be surrendered. Texas Family Code Section 85.022 strictly prohibits possession during the order. Emergency mental health detentions. Under Texas Health and Safety Code Section 573.001, police may temporarily remove firearms during a mental health crisis call. Seizure of evidence after a crime. Even if you're not the suspect, a firearm can be held as evidence during an investigation. Prohibited possessor situations. If a person becomes federally prohibited, like after a conviction or certain restraining orders, the firearm may be seized. Texas law provides a path to get your firearm back, but there are strict steps depending on why it was taken. Here's the breakdown. If your gun was taken during an arrest, once charges are dismissed or you're found not guilty, you may file a written request with the law enforcement agency holding the gun. Agencies commonly require photo ID, proof of ownership, copy of the dismissal or case disposition. If you're convicted of a weapons offense, the judge can order the firearm destroyed, sold, or returned. It's case-specific. If it was seized under a protective order, the gun is usually held until the protective order expires. You must request its return in writing, and you cannot be a prohibited possessor. Courts can require a background check before release. If taken during a mental health detention, the firearm can be returned once you are released and no longer deemed a danger. Agencies may require documentation from the hospital or mental health authority confirming your status. If held as evidence, release only occurs after prosecutors confirm the case is closed and the gun is no longer needed. Real Texas cases. Case 1, State v. Brown, 2020 facts. Brown's firearms were seized after a domestic violence arrest. The charges were dropped, but police refused to return the guns due to public safety concerns. Ruling, the court held that once charges were dismissed and Brown was not legally prohibited, the firearms must be returned under Article 18.19. Takeaway, agencies cannot hold guns indefinitely without legal basis. Case 2, in JM, 2018 facts. JM had firearms seized during a mental health detention. He was quickly released, but the sheriff's office insisted on a court order to return them. Ruling, the court ruled the firearms must be returned because the state provided no evidence that he remained a danger. Takeaway, mental health seizures are temporary unless extended by legal process. If you're finding this helpful, make sure you like this video, subscribe to The Right Slant, and hit that notification bell so you never miss content about your rights. Here is the exact process most Texans will follow. Step 1, determine who has your gun. Usually the city police, sheriff, or Texas DPS. Step 2, get the case disposition. You need proof that charges were dismissed, or you were found not guilty, or the protective order expired. Step 3, submit a written request. Most agencies require a formal letter. Include your full name, case number, copy of ID, description of the firearm, proof of ownership, reason the firearm should be returned. Step 4, background check. Texas agencies often verify you're not a prohibited possessor under federal law. Step 5, pickup appointment. You must appear in person unless your attorney is authorized. You cannot get the firearm back if you were convicted of a family violence misdemeanor. You are under an active protective order. You were convicted of a felony. You're otherwise federally prohibited. These restrictions come from federal law. not just Texas law, and agencies legally must follow them. In Texas, you don't lose your firearm rights just because your gun was taken, but you do need to follow the legal process to reclaim it. As always, the Rights Slant is committed to helping you understand your rights clearly and factually. Drop a comment if there's another state you want us to cover, and don't forget to like, subscribe, and hit the notification bell. Thanks for watching.